lordships would like, my lord, me to conclude early because of constraint of time, I can conclude, my lord.
No, but we are only saying that the governor should not enter the political.
I am not entering political arena.
Yes.
I am my learned friend. I expect him to, my lord.
Either, Malad, this statement should be recorded as the submissions of the governor.
No,
We'll
these
accept
are
that.
my submissions.
But he can't be, Malad, have an independent status, Malad, independent of the governor. He's not arguing for the governor and he's saying, I am arguing in my individual capacity. What capacity?
Lord, I'll not, my lord.
No, it's not fair. It's not fair.
Lord,
Because if I start talking about conscience,
say one. I'll just point out the flip side of the exercise which the petitioners have, my lord, called upon your lordships to undertake merely as an academic exercise. And the focal point of the entire defection law, that is the real sovereign, the elector, the voter, my lord, doesn't find place in any of these arguments. My lord, I just wish to, my lord, bring that fact to your lordship's notice. Lord, we do not have a two-party system. But India is a multi-party democracy. Something will go into the root of this issue. When I point out, my lord, the constitutional dilemma which your lordship would eventually face, my lord, if this is raised, my lord, and my lord sought to be answered purely academically. Lord, we have a multi-party democracy. Multi-party democracy would necessarily mean that now we are in the era of alliances. Lord, constitution always evolves based upon your lordship's experience of how the constitution has worked so far. How is it being used, abused, misused, not used, etc. In a multi-party democracy, there are two types of alliances, Lord, which are contemplated. One is pre-poll alliance and another is post-poll alliance. Post-poll alliance is usually, my lord, an opportunistic alliance, my lord, to complete the numbers, but pre-poll alliances are always principled alliances, and that is where, my lord, 4 paragraphs from Quixote, my lord, I would read after giving the preface of what I am driving at. Lord, in a pre-poll alliance, Lord, taking facts of this particular case, Lord, there was a pre-poll alliance between 2 political parties. Lord, I'll name the parties because all parties, my lord, are subject matter, my lord, between BJP and Shiv Sena. As Quixote, my lord, explains, when you go before the voter, you don't go as an individual candidate. You go as a representative representing a particular ideology. A representative who will go and say that this is our shared belief, this is our shared agenda. Don't vote for the other party for A, B, C, D, E reasons which are negative for the development, for your own upliftment, etc., etc. The voter does not vote for individuals, but it votes for the ideology and the political philosophy which, my lord, the parties project. Lord, here what has happened, my lord, we hear the expression horse trading in all defection matter. Here, the leader of the stable, my lord, took the stable away and started, my lord, he formed the government with those against whom, my lord, they contested the election, and a negative vote was given by the electorate against a particular party. Now, my lord, we come to, my lord, Quixote Holohan, my lord, in this background.
No, but Mr. Mehta, how can the governor be heard to say all this?
I am
on the formation of the government between the.
I am absolutely not on the morality part of it.
How can the governor have anything to say on
Lord, your lordship, my lord, stopped me a little early, my lord. I was coming to Quixote.
Yes.
Lord, what Quixote does was, Lord, when Quixote, my lord, was considering the constitutional validity of Schedule 10, there were 2 contentions raised. And why, my lord, I entered into the facts, not as a political argument.
When they form government,
not on that, but kindly allow me.
Governor asked them to have a trust vote. They got a trust vote.
Lord, let me make it clear. I am not arguing the list between the parties. I am arguing why Nabam, Lord, is a correct law. And my preface on facts is necessary so that I can point out, my lord, if your lordships would like, my lord, me to conclude early because of constraint of time, I can conclude, my lord.
No, but we are only saying that the governor should not enter the political.
I am not entering political arena.
Yeah.
I am not entering. Why I am saying this, my lord? And, my lord, therefore, my lord, I made a preface that there is a constitutional argument flowing from, my lord, these facts. And these facts may occur, my lord, in different variety of situations at various, my lord, stages in various states. And your lordship will not confine yourself examination to the facts of this case. Now, my lord, when Quixote Hilohon was examining the constitutional validity, there were two contentions which were raised by the petitioners who were challenging the validity. A, that this negates the freedom of expression of the electors, my lord, that is freedom of expression of the one who is elected, member of legislative assembly, because I as an elected person, I means not governor, but kindly take it as an academic argument, my lord, as a constitutional argument. I as an elected person, my lord, represent the views of my electors. So the argument was that unless and until, my lord, I express my views, you are curtailing 19(1)(a) rights. The second argument was right to conscience. Right to conscience. My lord, kindly see, my lord, some of the paragraphs in this context, my lord, if, and my lord, the purpose of my giving, my lord, this background of facts, my lord, which your lordship prima facie found to be, my lord, entering into the marriage, which I never intended to. My lord, please come to, my lord, compilation, judgment compilation, PDF 94. Because here, my lord, the pleadings are that we couldn't go before our electorate.
Tushar, that the governor.
We couldn't go, my lord, in a multi-party democracy, my lord, your lordship would encounter cases where, in principles, the elected persons will have to go against the leader, my lord, not against the party. And that's what, my lord, the weapon of Article Chapter 10 is not to legitimate dissent. That all right, you want to move this motion, let me remove you. I will decide. No, kindly see, this is a very, very serious issue. I am the speaker. I have the power to remove, and I will decide the electoral college who will vote in my no confidence motion. That is what is prevented, not under Article 181, etc. That is also one of the factors considered. But
Yes.
propriety, Lord, please, that I will not be able to go before my electorate because I went with a particular ideology and now I am sitting with an opposite ideology. I am not, my lord, on facts of this case. Right to conscience, my lord, is a right pleaded while challenging the constitutional validity of these provisions. And if your lordship were to lead power into the speaker to disqualify people, even in case of a legitimate dissent, exercising the right to conscience, not possibly, your lordship may have to revisit such challenges if made.
How is
Now-
the governor arguing all this? I do not.
105, my learned friend, I expect
fair.
him to, my lord.
Either, Malad, this statement should be recorded as the submissions of the governor.
No,
We'll
these
accept
are
that.
my submissions.
But he can't very much have an independent status, Malad, independent of the governor. He's not arguing for the governor and he's saying, I am arguing in my individual capacity. What capacity?
Lord, I'll not, my lord.
No, it's not fair. It's not fair.
Lord,
Because if I start talking about
I
conscience,
would say one
Malad,
thing.
then I can
My
say,
learned friend
I
got up
can
at
say,
a very
Malad,
opportune time. He
party
should
in
have
power
interrupted.
has a fundamental right to buy off people. Does that party in power have that right?
That's all right.
Let's not
Yes,
let's not make
Can you
allegations.
maybe, confine yourself to.
kindly, my lord. My learned friend, my lord, interrupted at a very right moment. He should have interrupted when I raised para 44. Should have.
Para 40.
I'll interrupt
Yes,
you again, don't worry.
But these are all submissions, right?
yes, my lord. Lord, now, my lord, these are the, my lord, findings.
Para
This is
40.
how, my lord, the court rejected these submissions. Your lordships would be, by conferring power on the speaker to disqualify within that 14 days period, with which, my lord, I have nothing to say, would be permitting, my lord, even a legitimate dissent. My lord, I am not on buying and selling and horse trading. I am on a question where, Lord, again, coming to the facts of the case when
According
out
to you,
of
Mr. Solicitor, what do you suggest with respect to the time frame, time within which this injunction against the speaker should apply?
Lord, it is for them to answer, my Lord, because they have the list between the
But we
parties,
take it
but
that therefore your
We are
contention is that it must,
I'll answer.
that the cloud must go back to the date when an intent to remove, remove the speaker is given by the form of a notice.
My Lord, the counter answer, my Lord, question which I already posed before your Lordship for consideration. My Lord, suppose I were
Is it
to
your
say,
case that the bar on the speaker adjudicating on a petition for disqualification attaches the moment a notice within the meaning of the proviso to Article 79, 179 is issued?
correct? The reason is this, look, the reason is this. No, forget the facts of this case. Suppose there is no dissent amongst the party members, but majority of the party members, not maybe 90 out of 100, wants to remove only the speaker. Only the speaker. There is no, my Lord, loss of confidence amongst the leader, namely the chief minister. He has done something extremely wrong and everybody wants that he is not stepping down, let us remove him by a motion of no confidence. What he needs is one application, my Lord, and he can remove 99%, disqualify 99%, saying that I am the elected speaker, I was elected under a whip issued by your political party, and this is how, ultimately it may be different thing that the political party may condone that defiance of the whip. But your lordships would be leaving everything at the sweet will and discretion of the speaker, who will be entitled to tailor-make his own voters' list, who will vote in case of his electoral, in his vote of confidence. That's the flip side I wanted to point out.
That's the danger.
No,
That's the danger I'm pointing out, my Lord, and kindly appreciate, my Lord.
Mr. Mehta, that is what Justice Misra has also observed.
Correct, my
What was
Lord.
the reasoning given by Justice Misra?
That, my Lord, in my respectful submission, my Lord, and subject to appealing to your lordships, is a correct reasoning. Lord, kindly appreciate, my Lord, here, again, not being political. I am giving an example, my Lord, to, my Lord, fit into this constitutional scheme. Out of 55 elected persons of a party, 40 people want the speaker to go. There is a lack of confidence. But the speaker says and the chief minister says, which, my Lord, prima facie fell from your lordship also, that the chief minister did not face because there was no disqualification, meaning thereby the chief minister would have faced the vote of confidence only after 40 people are removed and 15 remains. Lord, that perhaps
We'll formulate your point like this. The speaker should not be permitted to tailor-make the electoral college, which has the power to vote him out of office. That's the point.
That's argument. Another argument. Lord, suppose even if I were to say, well, because I don't have the list, that all right, read the provision that the moment a motion is brought to his notice, it has to be moved and, my Lord, culminated in either this, Lord, motion losing or motion succeeding within a particular time. Lord, your lordships may do that. My Lord, suppose I am suggesting. Kindly, my Lord, examine. Suppose the speaker himself doesn't call the meeting and continue to exercise the powers under the 10th schedule. The majority of the members give a motion of no confidence to the speaker. It is for the speaker to convene the house. He doesn't convene the house. He doesn't bring that motion to the assembly. And in the meanwhile, my Lord, he starts at the behest of one gentleman, my Lord, proceedings. These are the flip sides. Lord, therefore, the question is, my Lord, in facts of this case, Lord, does the question of correctness of Nabam Arabia arise at all? Lord, mere
I just
because
speak what I had said earlier. Your submission is that the speaker should not be permitted to alter the composition of the legislative body, which has the power to vote him out of office.
correct.
That's the long and short of it.
My Lord, last submission, and my Lord, kindly, this again, my Lord, is my worry as an officer of the court, my Lord. Lord, whenever you say,
Is being questioned.
whenever my learned friend may enter into politics and governor and how,
I have not-
I am on constitutional principles. My Lord, my worry is this. What is democratic principles? If I am elected in the house, I am elected as a leader of legislature party. Correct? My being a leader of the legislature party necessarily inherits my duty to continue to earn their confidence throughout my tenure. If I have my person as a speaker, then my accountability to the elected MLAs goes, my lord, because I will know that the moment somebody says that we have lost confidence in the chief minister, I'll be able to trigger 10th schedule through the speaker, and that remains, my lord, as a sword hanging. Therefore, I say 10th schedule is not a weapon to stifle a bona fide legitimate dissent. It is a weapon to control unprincipled defection.